And we are live. Hello, everyone. This is Tom Fox, and I'd like to welcome you to episode 33 of the FCPA Compliance and Ethics Report. It's really my great pleasure today to have my good friend and colleague, Bruce Carton, the founder, editor, and all-around go-to guy at securitiesdocket.com. Bruce has one of the best sites for all things SEC. He's a former SEC enforcement attorney himself, and now he runs probably the best portal for updated information on the Securities and Exchange Commission. Quite frankly, Bruce, I don't know how you do it because you come through with information every day about what's going on with the SEC. In addition to your daily updates, you have some of the best webinars that are available on a wide variety of topics. Certainly in my little world of anti-corruption and anti-compliance, you have, anti-corruption and anti-bribery compliance. You have a large number of resources dedicated to that, but your remit is truly as broad as the SEC. So you have some, for me, rather esoteric subjects that you talk about, but they're important to the SEC community.
Well, right back at you.
One of the things that I really enjoyed last fall that you came out with was your Enforcement 40, which really highlighted some of the great talent, SEC defense talent, I guess, here in the United States, rather in law firms. And I think that was something that everybody looked forward to as a great resource for go-to SEC attorneys. Certainly here in Texas, the Mark Cuban trial got a lot of press because of Mark Cuban and one of the really high-profile SEC trials. So that's on the mind of people here in Texas simply because Mark Cuban was involved, obviously outside the anti-corruption world. But what I really wanted to do was visit with you about some of your thoughts on significant events from your perspective on the SEC from 2013 and what they might portend for us going forward.
Well, first, thanks a lot, Tom, for inviting me. I really very much enjoy your blog and the work that you do. You're becoming quite prolific. And it's really great stuff. And thank you for the kind words about Securities Docket and the different things that we're trying to do here. But as to 2013, it's been a busy year. It's been a busy series of years. 2013 was no different. And as I tried to kind of sit down, I just wrote a column for Compliance Week on this same topic, just trying to look back and distill what had happened. To me, 2013 was really a kind of an inflection point in a year of change. It started out with the enforcement director, Rob Khuzami, announcing that he was on his way out, and he did leave in January. It also the introduction of a new chairman of the SEC, Mary Jo White, who replaced Mary Shapiro after about 4 years. The introduction of new leadership, particularly in the enforcement area, really has an impact on the things that happen. And in particular for Mary Jo White, with her background being a federal prosecutor, and not just any federal prosecutor, but a renowned and universally respected head of the Southern District of New York, coming into the SEC to try to shake things up and to really ramp up enforcement. Together, her arrival and the arrival of people like Andrew Serezny in the place of Rob Khuzami have really kind of set the stage for 2013 that saw some changes, saw some new events, but I think is kind of poised for some real interesting stuff in 2014. So I think it was an inflection point in that you have new leadership that is really going to drive the SEC in some different directions. We saw right off the bat that after, I believe, 30 years of a policy where if you were sued by the SEC, you could settle it without admitting or denying anything. Meaning, without admitting or denying is kind of an odd way to put it, but that's really the only way to express that policy. But so let's say you're sued by the SEC for insider trading. You settle the case and you, in writing, say, I don't admit to anything. but I don't deny anything either. And you're held to that. If you later come out and say, I never did anything, they're going to take the settlement away. Um, but for 3 decades, that was the way those policies worked. And um, that really started to come under attack, not just this year, but in the couple of years leading up to it. You had um, Judge Rakoff, who is in the Southern District, really was kind of the leader in this attack, and he did something that was really unusual a year or so ago, which is in the SEC versus Citigroup case. He was handed a settlement between the SEC and Citigroup, and he basically said, "I'm not going to approve this. I don't see any admissions. I don't see anybody taking any accountability. I'm just not going to do it," which was very unusual and really shook up the SEC. And their policies and their whole settlement program. So that case wound up being appealed, and it was taken to the Second Circuit. The Second Circuit heard an argument in it. But what happened was that other judges started to kind of pile on, and after a while, you had 5 or 6 other court opinions where judges who had at one time basically got an SEC settlement sent to them, and they would just say fine. What you started to see in last year in particular was some judges were saying, I'm not going to do it. I'm relying on Judge Rakoff. I'm not going to do this. I'm not going to approve it. So there were some other voices kind of in support of shaking up this policy, including Elizabeth Warren, the new senator. But what happened, to make a long story short, and I'll try not to be this long-winded in all of your questions, is that when Mary Jo White came on this year in around April, she immediately said, we're going to reevaluate this policy. And then within about 2 months, the SEC had told its staff, going forward, there are going to be some instances where we require companies to make an admission. Those are where there's egregious intentional misconduct, or where there's misconduct harming large numbers of investors. So that was a really very momentous change in SEC practice that was kind of brought on by the change in leadership.
One of the things that I found interesting was that as you said, Judge Rakoff really led the discussion of these issues. He really brought that forward and maybe even tied it up a little bit towards the end of the year when he criticized perhaps a little bit more the Department of Justice than the Securities and Exchange Commission, but really criticized deferred prosecution agreements and non-prosecution agreements. So he's continued to either be a thought leader or be a burr in someone's side. I guess it depends on your perspective, but certainly a very interesting change for the SEC. And I guess from my perspective, I would just say it's change, and it's change that companies need to evaluate closely and evaluate the other ramifications of signing such an agreement moving forward. So I'll be very interested to see how this plays out in the corporate world going forward.
There's no doubt that Judge Rakoff has kind of turned into the most prominent judge in the SEC world, both for the Citigroup type of situation I was just discussing, also for his very high-profile comments of late about prosecutions in the financial world. It seems like every significant case goes to Judge Rakoff. It's supposed to be random. What I believe is the case is when you're on senior status, you can pick some cases that you want. That's what I've been told. So maybe that explains why every meaningful case goes to Judge Rakoff. But he certainly seems to be the most prominent and saber-rattling judge in the SEC's world.
Well, after the change in the no admission settlement policy, what are some of the other things that you saw as significant from the past year?
A couple of things. One thing that seemed to jump out at me is that Mary Jo White has been saying for a while that and it's kind of attached to the no admissions policy, which is if you're not going to let people settle absent an admission, you're going to get some people who don't want to settle. There are many people who just can't admit to these things and won't admit to these things because of the collateral consequences. You know, if you admit to something in an SEC case, you may be held to that in the private securities class action, or you may wind up having that held against you in a criminal matter, for that matter. And so there are the presence of that new policy really, I think, is going to reduce the number of people who are willing to settle by some amount. We'll see how it plays out. The next ripple after that is you start to have more trials. And there were a number of trials, say, beginning October 1st, including the Mark Cuban trial that you mentioned. But I know that I think in the last 2 months, there has been 6 trials, I think. We'll bleed into January just a little bit. But there have been 6 trials, 4 jury trials. The SEC is 2-2 in those cases. 2 other trials that were bench trials that I think they lost. So they basically had 2 wins and 4 losses, as I counted. The message from the SEC, from Mary Jo White, from the enforcement unit is expect more trials in 2014. They are very adamant about the fact that they're not going to hesitate to take people to trial, and we'll see what the measure of success is in 2014. So far in 2013 and the first weeks of January, the results have been quite mixed. I mean, they usually have a very high level of success in their trials, 80-90%, somewhere up in that range, but it's been
Let's
much
explore
less than
that a little bit, because I debate the FCPA professor on this topic. I'm a recovering trial lawyer. I think you're probably in that category as well. And from my perspective, a loss simply means you've been to the courthouse. And I'm not really troubled by losses if the facts bear bringing a suit forward, particularly on the civil side. I understand things may be a little different on the criminal side because of potential loss of liberty. But on the civil side, I'm really not offended if the government brings a case and loses. What are your thoughts along those lines?
I mean, I hear you. I don't think people like Mark Cuban would really agree with that. People, it sounds great programmatically unless you're the one on the other end. And certainly Mark Cuban has spoken out about his opinion of the case that was brought against him. And there was a case that just was resolved in favor of a defendant this week, or maybe it was late last week, and the same kind of response from the defendant, which is this shouldn't have been brought. These kind of cases you have to have some kind of restraint on. So I mean, there is a great tension in those decisions at the SEC. You may have an issue that's close and you think you should bring it. In that case, I think I definitely see your point. You're going to have to push some things sometimes. Not these rules are not always clear. FCPA, insider trading, there's a lot of murky areas, and sometimes you wonder whether it would be better served to make some kind of concrete rules that people could follow rather than having to have everything resolved by litigation.
Okay. Any other thoughts from or areas from 2013 you thought were significant?
Well, certainly, I think there was a very significant development in the Dodd-Frank whistleblower world. So just to back up, for I think about 2 years ago, the SEC was ordered under Dodd-Frank to create the Office of the Whistleblower. And this was a new program basically designed to, I think as Mary Jo White put it at one point, as a force multiplier. So basically you get the world out there that has knowledge about fraud or misconduct that can lead to an SEC enforcement action can bring tips to the SEC. And they come into the whistleblower office, and the whistleblower office then has to distribute them to the right people, the right enforcement staff, who then can bring a case. And it was an enormously high-profile endeavor, an office that didn't exist before that was hopefully going to bring a lot of new cases. They have been getting somewhere around 3,000 tips a year. Um, but for about a year or two, the output from these cases was just nothing. You had one small case in 2011, if I have the year right. Maybe actually I think it was 2012. But they had a couple cases here and there, a $20,000 award to so and so, and there started to be some rustling. The peanut gallery of the SEC world was like, what's the big deal? Why was there such a big hubbub about the office of the whistleblower? You're not bringing any cases. The case you bring is 20 grand or 25,000 or 50,000. Those complaints seem to slow down or maybe go away altogether this year. The SEC on September 30th announced an award to a single whistleblower in the amount of $14 million, which is enough to get anybody's attention. So it really was, for the first time, a sign. This is why this is a big deal. You're going to have people, when they see $14 million, they may be willing to go to the SEC. That's a life-changing amount of money for most people. So that was a very important development for the SEC in September, to be able to announce that award. And it really generated a lot of interest and a lot of attention, and hopefully some more whistleblowers will come out of that. So that was a big deal. And I think maybe the other thing that really was emerging towards the end of the year, a little bit in the beginning of the year, was the SEC and the DOJ's efforts in the SAC capital cases involving Steve Cohen's firm. And you saw mid-year the SEC brought a huge insider trading case against CR Intrinsic. It was a $600 million settlement. And it was related to this guy, Matthew Martoma, whose name has resurfaced in December, January. He's the subject of a criminal trial for the same insider trading conduct. So the SEC, I don't want to get SAC and SEC confused, but the SEC brought a case mid-year 2013 against Martoma and CR Intrinsic. They later brought a case against SAC and Steve Cohen, but only in a supervisory way. On the criminal side, the Southern District of New York filed its own case against SAC, but not against Steve Cohen. And that case is a criminal case of insider trading in the Southern District.
Right. It seems certainly the comments of Chairperson White and the public commentary would indicate more aggressive prosecutions, more aggressive trial work, and that was one of the key ways the wind seemed to change for me over the past year. Or her thoughts on that, and then these series of pretty aggressive prosecutions in sort of the last half of the year.
Yeah, I think that's right. I think that looking to 2014, I think it's really the first full year that you have Mary Jo White in as chairman. It's the first full year that you've had Andrew Cerezny now, who for a time he was a co-director of enforcement with George Canellis. George Canellis has announced that he'll be on the way out of the agency shortly. So you're going to have the first full year of Andrew Cerezny kind of leading the enforcement division. And we've already talked about the trials, and we've talked a little bit about Mary Jo White's background as a prosecutor. But one of the other things that the SEC has been promising to really focus on, which is a clear change in policy, is financial fraud cases. So what you've basically seen, if you think back, the financial fraud cases have always been kind of the bread and butter, or a real significant part of the SEC enforcement program. Thinking through the early 2000s, when you had the very high-profile cases against companies like Enron and WorldCom and Tyco, those cases have really slowed down. And if you look at the statistics, they seem to go down every year. 100, and it was 90, then 80, and 70, and then 60 something this year. And I believe that the number of financial fraud cases brought in 2013 were the lowest in 16 years. Um, the SEC really made a point around September, October of saying that, and actually a little bit earlier than that, but that this was going to be a real area of focus for them, and that they were going to do a couple of things that really hadn't been done for a while to generate new cases, identify financial fraud cases to the extent they were there. They basically were saying, we haven't really been looking that carefully at financial fraud. You know, a lot of people believe that financial fraud is down in general because of things like Sarbanes-Oxley and better corporate governance, but we don't really know. So we're going to go take a very hard look and see what's out there and see how much fraud there is, accounting fraud, financial fraud, and bring the cases that can be brought. And the way they propose to do that differently than they have in the past, at least, is first of all, they've established a task force. It's called the Financial Reporting and Audit Task Force. And this is not an entirely new idea. They used to have a financial fraud task force years ago. They shut it down about 4 or 5 years ago. But they've created a new task force, armed with people whose job it is to find financial fraud cases. That's led by David Woodcock and Margaret McGuire. So you have people who are tasked with this function, which you haven't had in a while. They also have a number of new initiatives where they're trying to use technology to basically ferret out financial fraud. There's a computer program that's, I can't remember the acronym, but everybody calls it RoboCop. And RoboCop's job is basically to pour through filings, pick out aberrations and keywords and flag potential financial fraud, as a computer would do. But there are a number of initiatives kind of like that where they're trying to use technology to flag financial fraud issues that humans can then go follow up on and find out whether there actually are any kind of issues. And then they'll look at hedge fund performance, and if there's 1,000 funds that are right here and there's one that's up here, that one may get a call. They're trying to really kind of, in short, use technology to flag and identify financial fraud. So the commitment is more financial fraud cases, or at least more attention to bringing the cases that can be brought. That's something that we really haven't heard for a while. I think you're going to still see the same insider trading focus. That seems to be a constant. But the last point I would mention, kind of on that aggressiveness, is at the Securities Enforcement Forum in October, Mary Jo White spoke, and she kind of gave this strategy. She expressed her enforcement philosophy as kind of following that broken windows philosophy that they had, I guess, in New York back in the 80s, which is don't let anything go. Because letting it fester or kind of sit there unaddressed suggests that people aren't paying attention. And what she said was basically, nothing's too small. Anything out there that we can bring, we're going to try to bring, or at least give the perception that we're looking everywhere and doing everything. So, I mean, that to me is a sign of somebody who wants to be aggressive.
Right. Bruce, if I could turn now to Securities Docket, and could you share with us some of the upcoming events that you might be hosting?
Well, sure. So you're right. We do webcasts every other week or so. For those of you who are interested in kind of a 2013 review, something along the lines of this, but with other voices, other perspectives. Last week I just did a 2013 year in review type of webcast. That's the most recent webcast that we've completed, but that was with Bill McLucas and Doug Davison. Bill McLucas, if you don't know, is the former enforcement director at the SEC, the longest tenured enforcement director ever. But he and his firm are right in the middle of the SEC enforcement world, and they are very plugged into what's going on and what probably be going on next year. they, together with a firm called FDI, put on a webcast that I would highly recommend. It has some good materials and really covers what happened last year and what to look for in the coming year. Going forward, we have I think two more webcasts in January. One about proving and defending fraudulent transfers. One about CFO liability, and then in February we have, and you may want to tune in for this, Tom.
Already signed up.
Okay, well, it's anti-corruption, both the FCPA and a global review from the lawyers at Gibson Dunn, who are, again, the right people to be telling you these things because they are very much plugged in to that world. Other than that, just keep an eye. There are lots of webcasts. There'll probably be 30 webcasts in 2014, so they're going to be continually added to the calendar. The other thing I would mention is I mentioned the broken window speech that Mary Jo White gave at the Securities Enforcement Forum. That's another initiative that Securities Docket is involved in. We organized that conference over the last 2 years, and that'll be coming up again in October. It seems to get bigger and more fun every year. Tom, I'm hoping you'll join us this coming year. But the early word on it is looking great. A lot of great speakers. We have a panel of enforcement directors, including Mr. Serezny, who's currently the director, but Mr. Rob Kuzami, Bill McLucas, Stanley Spork, and Linda Thompson. A panel of, we call it the directors panel, which is a high-level, very high-level look at what's going on in the world of enforcement and what's coming up.
Do you have a date for that event set?
Yes, it's October the 14th in DC. I think it's October 14th. Yeah, October 14th in DC at the Four Seasons. And I just confirmed recently that Preet Bharara, the U.S. Attorney for the Southern District, is going to be our lunch speaker. So that should be great.
Oh, that's worth the price of admission alone.
Thank you. I hope so.
Well, Bruce, we're at the end of our time, and I wanted to ask if any of our listeners wanted to get in touch with you, how would they do so?
Happy to talk to anybody who has any questions or thoughts, or the easiest way to contact me is just by email, and my email is bcarton, like my last name, so BCARTON @securitiesdocket.com, and I would be happy to talk to anybody about anything.
Well, Bruce, thanks a lot. Once again, for our listeners, if you don't subscribe to Securities Docket daily feed, you need to do so. So I would suggest you go to securitiesdocket.com and sign up. Also, Bruce writes a column monthly for Compliance Week, which is a great resource as well. So I'm looking forward to your thoughts in writing. So with that, thanks a lot, Bruce.
Thank you, Tom. It was fun. I appreciate it.